Hello, this is Matthew Chan, and I'm on the phone here with Oscar Michelin. And at long last, I know a lot of you have been asking for this for many months, an update. And we've been getting all kinds of flack about not providing an update. It's been a year. So, Oscar, let's not make our audience wait. Welcome to the call.
Hi, thank you for having me back, and let's get this information out there for people. I know, like you said, Matt, I've received so many emails from folks saying, hey, the last video or last phone conversation was back in 2009. Has anything changed?
Yeah, I know. I've been getting some of those, and as you know, we get tugged off with the day-to-day things, and, it can be hard to sometimes just find some time and just make a recording, So, but anyway, here we are, and we hope that you listeners will be excited about this new information. So, Oscar,
I do want to say, Matt, if you just hold me for a minute here.
Oh, go ahead.
Before we get started, I do want to say that the forum part of the website is really very interactive, and either you or I are posting on there nearly daily. Certainly not more than 2 days go by where either you or I do not either update someone or respond to a question or respond to a post. The other thing that I've really enjoyed about the site, and I'm sure you've seen this, is that we've developed a community.
Oh, absolutely.
We've got regular people who post on there, people who provide us with information, and they're hearing about things. They're asking great questions. They're keying in on these issues. They're keeping track of what Congress is doing. They're keeping track of what the large digital image warehouses are doing. So while we may not be able to always get an audio or video update up as often as we'd like, folks should always remember that the forum is the place for really up-to-the-minute information.
Oh, absolutely. That's unquestionably true. I mean, we've got some of our little foot soldiers, and guys, I know you guys are listening. Please don't take that as a derogatory term. We are very grateful to your participation. But, we've got our little, we've got our helpers, feeding us information, helping be in our eyes and ears over issues. So it's been an interesting phenomenon that's really been happening this past year.
As much as we'd like, as both everybody knows who knows the site, you and I have our own businesses,
absolutely,
and areas of practice outside of this one.
Yes.
And while we're keeping track of the day-to-day issues with this area, we can't possibly hear of all the various problems that are happening in other states and, frankly, other countries of the world, because a lot of international folks write to us and post on the forum, and it's just been great to have those posters give us updates and also to help us think outside the box, think about different areas that we could explore, keeping track of what some of these companies are doing with respect to the language that they're putting in their documents and their materials, et cetera, et cetera. So it's been really a great source for people, and I recommend highly that anyone who's involved in this area in any capacity, whether you've been a recipient of a letter, whether you're a lawyer who's got a client in this area, whatever, look to the forum, look at the posts, and I think you'll see that you'll benefit greatly from that experience.
Yes. Well, I think I think our audience will really appreciate you saying that you like their participation, because everyone obviously looks up to you as an intellectual property attorney, and I think it's very rewarding for them to hear that even someone in your position appreciates their feedback and commentary, and they stimulate your thinking.
Especially, you have to understand, our core client is not the big Fortune 500 monolithic, company. Our core client is a mid-sized to small business, usually a web entrepreneur, a startup,
yes,
somebody innovative. I mean, that's who our typical, if we have such a thing as a typical clientele, that's who it is. So obviously, with that type of client base, we're going to have a higher appreciation for folks who blog, folks who post, folks who, are looking to put information out there And we're very quickly. If you look, actually, Matt, and we're off topic a little bit, but I think it's important.
Mm-hmm.
The level of our posters, the folks who post, on our sites, are very high quality guys. And if you look just from the material that they present, and it's not the yelling and screaming and thumping.
No, absolutely not.
In a while, it's really very thought out, informative questions and opinions from people all around the country that I got to tell you, and you can see from my answers, I put up great posts. I love, you're on the money. You're right 100% correct, or, I hadn't even thought of that, and it's been really refreshing.
Well, it's funny you should mention about the quality of posts. As a moderator, you're always a forum moderator. It's been my experience. You're always having to keep out the spam and the people who cause a lot of trouble. But surprisingly, with our area of discussion, which emotes so much passion out of people, I haven't had to do that, really. There hasn't been that much name-calling. There hasn't been profanity. There has not been any outrageous posts. I can't even remember the last time I've deleted a message on the forum, which is really very surprising to me.
Yeah, you're absolutely right, because you look at these other forums, and you see that happening on a daily basis.
Oh, my God. I mean, they just blow up. I mean,
yep.
FSB and the UK shut down because of that. I mean, if you remember that. I mean, they couldn't handle it anymore. I mean, there was just too much name-calling and all this stuff, and the moderator just got fed up. And it was like a huge database, and we were sending traffic over there, for people who are in the UK, but there's nothing to send now. I mean...
I know. It's a shame because, the digital image issue is rampant in the UK, and they really need a resource. And, I'm going to say at least a couple times a week, I'm asked, can we get involved? And as I've said on other posts and other audios that we can't, because obviously we're not licensed to practice in the UK.
Mm-hmm.
But there's no real law firm that stepped up there that won't charge traditional fees to try to help people out, and that's
it is kind of surprising. I mean, they haven't seen what we've done over here. You'd think that they would say, "Hey, this is a great idea," or they'd at least pick your brain or something like that. I mean, we'd be happy to help them.
Right. Of course, 100%. And it also kind of explains why it is so rampant and so expansive now, where it started off relatively slowly in the UK, and at least the FSB forum was a place where folks could go and have discussions with other people that had gotten the letter and seen what had happened. So,
we feel bad for them.
Generate.
Yeah, but we invite them to use our discussion forum in the meantime.
Of course.
Until someone decides to come up, help them out in the UK. So, anyway, let's go ahead and jump in on the Getty update. What's burning on your mind, Oscar? What is burning? Let's start off with what? We're up to what? 500 some clients now?
We have approximately somewhere between 450 to 500 businesses that we've helped in the Getty issue. That does not include other digital image warehouse companies that are also following the same program.
That's a staggering amount of clients. I mean, could you have ever imagined in such a short amount of time you would have 500 new clients?
No, I originally only got involved to help you. I had no idea that I would have anybody after I helped you. And,
well, thank you for that, I guess.
I guess that it's like what they say about when comedians say, how do you know what's funny? And people say, you know what, if it happened to you and it's funny to you, it's been everybody else's similar experience. There is no unique human experience. And so this is really the same type of thing where we said, let's see what else is happening out there. And, you know better than anyone because you developed the site. It was almost instantaneous, the response.
It did not take long, I have to tell you. It did not take long. I was really surprised.
It was amazing, right?
Yes.
And I'm going to say that what's funny is we're also kind of, in a way, the victim of our own success because we have so much information out there, and we have so much either documents or forum answers.
Oh, I know.
Videos that a lot of people are saying, you know what, this is great. I got it. I got this. I can handle this. I know what the issues are. And it's been tremendous because people have written us, thank yous and just updates that, hey, I use this to make this argument, and I really appreciate it, and I had never heard of that type of an issue. So we're trying to give people some information as a resource, just in the IP field. But now what's been happening, interestingly, is that a lot of it has stayed the same in the sense that there isn't that much change, particularly in the Getty area. The program has been pretty much the same. Getty does not register their images, and therefore they are not entitled to legal fees, which kind of makes it much more difficult for them to file lawsuits. However, in the Getty area, one thing that has occurred that's important is that since we've developed the site, one of their biggest collections, what happens, Matt, is these guys, they buy catalogs from photographers, or they buy the rights to use the images, to license the images, to sell the images, etc., from photographers. Getty doesn't actually own the images. They license the images on behalf of the photographers and get a fee, which they share with the artists. But they then collect them in compilations. One of Getty's most popular collections is a collection called Stone. And anyone who gets one of these Getty letters will see that they always have a little catalog page that will show the collection from where the photographs were, were on the Getty catalog. Was it Stone? Was it Hill? Whatever there are different names for the collection. So Stone is one of the largest and one of the most popular Getty collections.
Why is that?
Compilations. Just because it's one of the biggest, and it has, by the way, these are pictures that we're talking about, two men shaking hands, woman on cell phone, tree on a hill. All right, they're stock images is what we're talking about.
I see.
But what happened is, because of a lawsuit that Getty did file over, I think, a repeat offender, the Stone collection was finally registered with the Copyright Office in 2008, I believe.
They were a little slow, huh?
What's that?
They were a little slow.
Yeah, Matt, they had never registered a single image. So the fact they registered any collection was a big shift in Getty's business model. And so what's important is when people get a letter from Getty, and if it contains images from the Stone collection, they should, ask Getty for the registration of that collection, if that was part of the image that was registered when Stone was registered in 2008, and then they should try to ascertain whether their Stone images were on their websites before the registration, because then Getty still cannot get statutory damages, penalties, and legal fees. They can only get quote-unquote actual damages. So that's been probably the biggest change that's specific to Getty, and it's something that folks, should look out for. The other collection is Taxi, for example. It's another very big collection. Almost every letter that I've seen includes one image from either Stone or Taxi. And we're talking about a collection, by the way, Matthew, of tens of thousands of just so many images. Okay, that it's a huge compilation. So that's why it's so common and so frequent to see that. And they're probably normally the kind of regular stock that's offered at a lower price or what have you. So.
Well, what does it allow Getty to do once it's been registered as a compilation?
Well,
could you elaborate a little bit on that?
If you infringe on any work of art, everything is called a work, whether it's a photograph, a statue, a novel, a song. The generic term is a work. So if the work was registered at the time of your alleged infringement, then the owner of the intellectual property rights has the right to collect statutory penalties and damages, which can range from the minimum is $250, and the maximum is something like $30,000. It can go up to even higher numbers of $150, etc., based on the nature of the infringement. So it also allows a court to award legal fees. And that's the real difference maker, because a lot of these companies would not go forward if they didn't at least have a chance to recoup their legal fees.
Well, the burning question that I know a lot of people are going to ask is Getty going to sue, assuming that the images have been registered?
Well, I guess we'll have to wait and see. It's a good point. I mean, we'll have to wait and see. We have not yet come up with a client who has developed his website after 2008 using the Stone collection, so that we don't have any personal experience or knowledge whether Getty is dealing with those differently. And if people do fit into that category, I ask that, you know what, put up a post and tell us what's happening so that we see how Getty is dealing with that. As long as you, by the way, of course, have not, signed a confidentiality agreement as part of a settlement. But if you're not bound by any confidentiality agreement, please tell us what's been your experience if you've gotten a letter from Getty where they do have a registered image. But what we can do is kind of use an example of what Masterfile does.
Okay.
And Masterfile, which is a Canadian corporation, is the opposite of Getty in that it registers almost all of its images are registered.
Well, they probably learned from Getty. Who knows? Or their competitors.
Well, you know what? No.
Or maybe they have a different business model.
Curious. A lot of people ask, and I'm going to get to this, I guess, a little bit later, but I honestly believe that Getty may not have registered the images as a compilation because they were aware that did not give individual protection to those images anyway. And so they said, why am I going to go through the trouble of doing this when I'm not going to be able to individually protect the images anyway? I mean, they're a very savvy company. This is one of the largest, most savvy, most current companies in the world. Okay, they are international.
Yes.
And they, it's not like they don't know the law, and they didn't forget to register the images. They made a business decision not to register, right?
Well, yeah, it was probably a business decision, a calculated decision.
It was a calculated business decision
yes.
not to register. So, Masterfile registers in compilation form, and they will sue. We have seen Masterfile sue all across the country for a single image, for 4 images, for 5 images. They are much more aggressive. They have gotten their legal fees. They have been awarded legal fees in cases.
Even for a single image?
Yeah.
That's a little bit hard to believe.
Yeah. Well, what happens is a court will look to see whether you made a reasonable settlement offer. In other words, the court's going to want to see who really caused the litigation.
Right.
Was it the digital image company because they wouldn't accept a fair number for the damages? Or was it the alleged infringer who, even though he was shown proof that the image was a registered work of art, nevertheless never made a reasonable settlement offer? So, we settle cases with Masterfile on a fairly regular basis. Sometimes when we don't agree on the number, it goes into litigation and it gets resolved in litigation. We have a number of litigations that are pending with Masterfile across the country.
Is that right?
And yeah. So we are aware that it's a different kettle of fish than Getty Images is, and I think right from the beginning, you and I have always said this site, this website, this letter program, all of this is not meant to encourage, support, or justify infringement of intellectual property.
Oh, my God, no.
It's exactly the opposite. You're a creator of intellectual property. We represent a lot of companies that ask us to enforce their intellectual property rights. This is mostly about the manner in which these companies are trying to get damages from people, the obscene amounts that they request.
Oh, no kidding.
Right, and the heavy-handedness of the method is what we're objecting to. And I think that if they come in with a rational number, then we advise our clients that's a fair number. You have no proof that you had right to the image. They have proof that you registered. If you go to court, you're likely to lose, and it's going to cost you more to litigate. So let's find the right number with these companies, and 9 times out of 10, or 9 times out of 9.5, frankly, we're able to get to that number where everybody is not overjoyed, but feels they got a fair result.
Well, it's funny you should mention that, because I was remembering my own case, and they had, when I negotiated with Getty, they had made some progress, made a little bit of progress, but at the end of the day, you're right about that. It was the heavy-handedness. It was, I felt like I was being extorted. I explained the situation. At the end of the day, I had just gotten so angry, I became less receptive to what they did. And I felt like they weren't, quote-unquote, being reasonable, which really spawned the birth of this, website,
Exactly. Right.
And, of course, you.
So,
it was that simple. If you'd be reasonable, I was willing to pay something just to make it go away.
Right. Or to even just fairly compensate them for what happened to them.
Yeah.
Now the other, because again, the other thing is, we're talking about folks who did not go onto the Getty or Masterfile websites and steal images. The vast majority of our clients are end users who asked somebody else to develop their website.
I know. There is no shortage of it. I just got off the phone with a lady in California. I just and I had to tell her. I was like, your story is an old story. I'm sorry to tell you. It's the same theme over and over.
Exactly. It's like, yep, I've heard that before. And what it is that people don't realize that you're still technically responsible under the law.
And they get pulled in.
Take that image, they get pulled in. And while they may have a great claim against their web developer, and probably about a third of our clients, by the way, are developers who have hired us to help their clients who've gotten in trouble because they feel responsible.
Oh, is that right? That's good to know.
Oh, definitely. Oh, absolutely. Absolutely. A full third, if not more.
Really?
If not 40%. We get hired by the developer and says, look, you know what? I feel bad. My client did this. My client got this letter. I developed this website. I got it from this site that said it was a free site, but I didn't check. And I got them into this mess. Let me hire you to help us get them out of it.
Well, let me publicly commend them for doing that, because mine didn't do it, and others. There's a lot of web developers. They've disappeared into the night. They're not coming out of hiding.
Absolutely, and you know what? They're overseas.
Yes.
They're a one-man operation. Now they've moved on to bartending. They've done something. You know what I mean?
Somewhere in the U.S. too. Somewhere in the U.S. Unfortunately.
That's what I'm saying. In the U.S., they were doing web developing, maybe in the late 90s when it was really hopping, and then when it died down, they stopped doing it. Now you go try to find them, and they're working at a Burger King or something. And so it's a position that you're left holding the bag.
Absolutely.
For somebody else's wrongdoing, and that's distasteful.
It is very distasteful. And that's one. Before I had met you and we discussed it, I would talk to some of the other so-called attorneys who were knowledgeable, and they were saying, they would read the law and say, well, you are liable and this and that. And I was like, well, you know what? Forgive me for thinking with, that there may be some actual common sense in the court, despite what it may say. There's got to be some middle ground here somewhere. There's got to be, somebody that can understand what's going on. I can't believe it's so black and white.
Right.
But you've already explained it very well.
Right. Unfortunately, if you look at our posts and our posts that discuss the Getty issues, we do, kind of let you know where the law lies on this, and the digital image companies are allowed to go after the end user only. But that's old news.
Yes, very old.
On the new news front,
yes,
one thing that is interesting on Getty I forgot to mention is that they've lowered, in a lot of cases, they've lowered their settlement demands.
On the letter, or are you talking about after it goes to negotiation?
No, in the letter, in the first letter, they used to ask for $1,000 every time.
Yes, it was at least 1,000.
Right. Now, while on some letters they ask for $1,200 an image, those are few and far between.
Is that right?
The vast majority of letters are asking for $875, $600,
interesting,
or $450.
That's very interesting.
And I got to tell you, I got to think that's kind of an impact of what we've been doing, try to educate the public to see what actual damages are worth. And very often when a client gets a Getty letter that says it's $400, I tell the client, look, call them up. Maybe you can make a settlement for $100. If they only want $400, and then it's just not worth spending even the $150 on me to retain the letter to write the letter.
I guess it becomes more palatable when it starts getting down to the $500 level.
Well, this is my whole point, which is and when we're not able to reach a settlement and we write a letter to Getty, we really put in this. And by the way, we appreciate that you've lowered your settlement demand, but you're not there yet. You're not really at what the number ought to be. But thanks for at least willing to show some flexibility finally. And I think that we are in talks to try to see if we can reach a global settlement of this whole thing.
I wanted to ask you, what's the status of your discussions with them?
I don't want to talk about it because we are trying to see if we can come to some kind of terms. I do believe that all of these digital image companies do check our website regularly. I can tell you that I have been in court, and in almost every court that I'm at, our adversaries mention the site and that.
Oh, is that right?
Oh yeah. Always that's well, Your Honor, you should be aware that Mr. Michelin has his website. I'm on a website, but it's my client Matt Chan's website. But in any event, that's kind of they don't really care about that. But so what we're trying to do is say let's really figure out what this infringement is worth. Let's assume you're right that these people infringed your thumbnail images. There's a number out there that's fair for this loss, and we should have a sliding scale, based on the number of images, the length of use, the manner of use, and pick a fair number that is what the person would have paid plus a little something extra, and we'll be done. We'll agree that this is a fair rate, and we'll try to settle along those terms. So maybe that's going to happen. We've been having that discussion for a long time, for the better part of this year, and I don't know whether we're ever going to be able to come to terms. I certainly hope so. One of the points that we'd like to make certain is that we feel anyone who's already in the program and has already received a letter we've responded to should get kind of an amnesty. There should be an amnesty period.
Mm-hmm.
And then we start fresh, for people, say in 2011 and forward, that type of thing. But
what do you think the holdup is?
No, I don't know. I think it's a big company.
Yeah.
It's an international company. This is a very important part of their business.
Revenue stream.
Well, yes. You know what? Of course, it's a revenue stream, but also let's face it.
Yeah.
They're the largest holder of digital images. They represent the most photographers. They have the most images. They publish the most images.
Yes.
They make the most money from images. So they're maybe Corbis, Masterfile won't like to hear this, but the fact is they're the industry leader. So
yes.
So they've got to really take a look at this because what they do could affect the industry. And it's funny, we started a little website, but it really goes way beyond it because it could be applicable to all kinds of other matters down the road. And I think they just want to try to decide what's fair to them, their photographers, and to those folks who get their letters. And hopefully, I'm giving them the benefit of the doubt that they're really trying to come up with a system that's manageable, that's fair, and that can get everybody a little bit of what they want. Like the good saying is, the old saying is that a good settlement is one in which nobody's happy.
Right.
Because if one person is ecstatic, then that meant he got away with something, or he got more than he expected, or what have you. Both people should kind of feel like they could have done a little better.
Well, it'll be interesting to see how many cases they want backed up. Do they need to get to 600 or 700 cases? Where you get that many to have it all backed up?
I don't know. I mean,
it'll be interesting. They all need to get resolved.
They do need to get resolved. They can do it a number of ways, though. They can handpick, let's call them the worst offenders, people with like 15 images or more.
Yeah.
For example, Getty does sue if they found that you've been a prior recipient of a letter and did it again. They're going to sue you. Okay?
Yeah, I guess they're probably less forgiving at that point.
Right. So they're going to come at you. They can kind of pick and choose which cases to sue. They can. I don't think they're going to go and sue everybody all at once. They can't do that financially, and they can't do that logistically. So, I do expect that at some point we'll be able to come to some amicable resolution of this whole issue. That's my hope.
So you sound like you're still reasonably optimistic.
Yeah. I mean, you know what? That's a good segue, because I'll tell you why I'm reasonably optimistic. I'm reasonably optimistic for the reasons that there have been a number of legal decisions, court decisions, that have, let's just say, bolstered our position on this whole issue. So I guess this would be a perfect time to talk about that. So there have been, let's just say, two predominant cases, both of which are discussed at length on our website, so I'll just discuss them briefly here. The first was what I call the Country Day bicycle case, which involved master file. And in that case, the defendant didn't even fight. It was what's called a default, okay?
Mm-hmm.
And master file sued based on their letters like they did with so many other people. They defaulted, and the judge said to them, okay, now show me what your damages are worth. So master file said, well, this individual took X number of images, and it was off of this one compilation, and therefore we want, $15,000 or $30,000, whatever they asked for. Okay. Well, the judge said, well, wait a minute. You register these as a group, a compilation, a big package of images. No matter how many images you take from that compilation, that's a single infringement. And the way you want to think about it is, it's imagine somebody suing over each individual page of a novel.
Right.
Okay? And the court is saying, wait a second.
It's still one novel.
It's the whole novel.
Right.
Okay? You filed it as a novel.
Right.
If you wanted individual protection for that page, you should have registered that page alone.
Absolutely.
As an independent work of art. So that someone has to take the whole compilation for you to get really damaged, but when anyone takes any part of a compilation, this court said, you are held to a single infringement. So the court awarded $1,100 for I think it was 9 or 10 images, I can't recall now.
That had to just take the wind out of their sails just a little bit. That just had to.
It definitely did, except that they also got
legal fees
under $5,000 in legal fees. So it didn't cost them anything.
Yeah.
They got all their legal fees back.
Well, on paper.
And they got some. Well, you're right. That's an excellent point. They
on paper.
Judgment.
I mean, they didn't bother to show up. What makes us say they may actually have paid on that judgment? And maybe it's a paper judgment.
On the judgment. And these are, by the way, these are the arguments that we make to them all the time. You're going to just put people out of business. They'll just close up, open up with a new name, and then you're stuck with holding the bag.
Right. Better to collect something. Yeah.
Right. Exactly. The Country Day case, the bicycle tour case, certainly gave us a warm, fuzzy feeling because it vindicated our position. And I also disagree with it in large part because the court, and again, this is the problem because these people did not have an attorney.
Mm.
It's funny because the court said the plaintiff is entitled to legal fees because the defendant never made a reasonable settlement offer.
Mm.
Well, the record showed that the bicycle tour company did make a settlement offer of around $1,000, and the court awarded $1,100.
Did we ever find out why they didn't show up? I mean, is that company still in business?
They never contacted us. I sent them a letter, and you know what? I just get the feeling they said, we don't want, we're done with this. You know what I mean? It's like the old saying, when if a cat sits on a hot stove, it's not even going to sit on a cold stove next time. It's just going to avoid stoves altogether. And I think
love that.
They never wanted to hear Master File again. Okay, so they never responded.
But are they still in business? I guess that's my question.
Not that I could find.
Really? You think they just said, well, we're closing up shop and that's it?
Right, and I think when I wrote to their old address that was, from an old piece of literature, they might also say, well, we can't respond because we've told we're out of business, right?
Mm.
This company is no longer in existence.
Mm.
So, they're done, whatever. But it was an important decision. But now, following that really helped us a lot, by the way, in trying to show Master File the risks. You know what's very important, and this is a real subtle thing, but Master File did not appeal that decision. Okay?
Because?
Now, not because they agreed with it, but that decision is a lower-level decision. It's a federal court. It's the federal trial court, right?
Mm-hmm.
So that is not binding on really anybody. Even though it was the first decision in the country to decide this issue, compilation-type registration, that federal judge in New York cannot bind a federal judge of the same level in Arizona.
Mm.
He can't even bind the judge in the next courtroom.
Interesting.
The same level. But
it does provide some direction and guidance.
It gives some guidance.
Right.
But now, if you appeal it and you lose,
it affirms it.
It affirms it. The Second Circuit covers multiple states.
Wow.
Including the entire state of New York, the entire state of New Jersey, Connecticut, etc. So the Second Circuit, now, anywhere in the Second Circuit, that would be the law of that circuit.
And they probably didn't want to take that risk.
Right. They didn't want to take the risk. Now, obviously they should take a risk on a case where there's a default because there'd be nobody arguing on the other side, right? But they didn't even do that. So I think it's a clear indication to me as a litigator that Master File's lawyers said to their client, it's best to leave this be. It becomes a single, isolated case, and it doesn't bind anybody.
But also, didn't you... Well, I mean, this was in a different context. The fact that you go after somebody that doesn't defend it doesn't necessarily make that decision any stronger. I mean, just because, you win because the opponent doesn't show up doesn't mean you had a good argument to begin with, right?
It does allow... You're absolutely correct. It does allow you to make certain arguments that you could say the other side never raised, so it doesn't apply to us, Your Honor. You could say that. But the other side did show up to contest damages, Matthew.
Oh, okay.
They sent in a letter. They didn't appear by a lawyer.
Okay.
They sent in a letter, and the court read the letter and the affidavit that was attached to it.
And they accepted the letter? The court accepted the letter?
Look at the affidavit, yeah. And I think that's where the court learned that they had made an offer of $900 along those lines. So the court's legal reasoning is its own, right? It's not the lawyer's argument. It's what the court feels. Mm-hmm. If it went up to a higher court and the court decided that, then that would be binding whether the other side defended it or not. And don't forget, Master File did appear by a lawyer
Yeah.
So if they lost, it certainly would be binding on them.
Oh, of
because
course. It would really make them look bad.
It would be only the other side, the alleged infringer, who would say, wait, you can't use that case against me because that guy didn't even argue anything. But now, following that case, came the case that I think is a landmark case in this area. And we've talked about it so much on our blog. There's at least, I'm going to say, 20 related posts to the case of Munch, M-U-E-N-C-H, I believe. Maybe M-U-E-N-S-C-H, I don't know, but you can find the can find the case. You can find all of our discussions about it on our forum.
Well, can you give a quick summary of what it is?
Yeah, no, of course. I have to, because it's really vitally important.
Okay.
It's vitally important.
Okay.
Okay, so here's what happens. You're a photographer. You give your photographs to one of these digital image warehouses.
Mm-hmm.
They register them if they're not Getty. Then they give you your rights back. Okay? And you share the right to sue over your photographs. Okay? So what happened is a photographer found that his photos were being used, he believed, wrongfully by a very large publishing company called Houghton Mifflin, one of the biggest publishers in the United States. So he decided, I'm going to sue Houghton Mifflin. Now, what's interesting about this is if you look at these digital image companies, they very rarely take on the big boys. They like to go after these mid-sized, small companies that can't match the 1,000 and 1,500 lawyer firms that they use, in their defense, or their 100 lawyer, 200 lawyers. They get these very large, national law firms to represent them. Well, what happened was this wasn't one of the digital warehouses. This was an individual photographer, and he picked on a big lion.
Why do you think they did that? Because there's more money to be had?
No, they didn't know better.
Oh, my gosh.
Their lawyer, you have to understand something. Just like we spoke about with Getty, when Masterfile sues, when Corbis sues, when Getty sues, they have issues outside of that case, right? Because they've got tens of thousands and up to hundreds of thousands of images. So they have to be careful about setting precedents. But for the photographer, that's their only photographs, right?
Yes.
They don't care about the industry. They only care about this one particular case.
Right.
So that's why they'd be willing to take on a big case, because they're not thinking outside the box of their own personal issues.
Yes.
So they took this on, and they lost big time, because what happened was, and I like to think that maybe the guys at Houghton Mifflin read our blog, because a lot of what their arguments made are very similar to our blogs. But frankly, any lawyer who's well versed in IP law would hopefully end up on the same page here with us. Although the lawyers for the other side would definitely disagree. The judge, who is the administrative judge for the Eastern District of New York, it's Loretta Preska. P-R-E-S-K-A, Judge Preska, very well-known judge here in the New York area. Sits in the federal court in Brooklyn. She decided that not only does a compilation count as a single large registration, but, and it, if we had a drum roll, we would give a drum roll, please. It provides no individual protection for the underlying images unless you list on the copyright registration each and every author of each and every image.
Holy cow.
And that even then, by the way, she would probably then agree with Country Day Bicycle and say you still get one infringement. So she did not even award a single infringement. She said you get no damages for any image where you were not specifically listed as the author. Now here is the kick in the butt that really shook the walls of these companies all across the country.
Okay.
What happened was, when these companies decided, how can we save some money by registering all these tons and tons of images that we have, so we don't have to go and individually register the images, they did what any reasonable company would do. They wrote the Copyright Office. They got their trade association, their lobby group, their trade association, to write the Copyright Office for an opinion. And they said, can we register our pictures, as an automated, updated database and get protection for our images in that fashion? The Copyright Office wrote them back, and they wrote and said, yes, if you do it in this fashion, compilation form as an automated updated database, that will give you individual protection for the images contained in the database. Okay. So they have been throwing that letter in my face, Matthew, for 3 years. And I should be able to, from my earliest files, pull out letters where I write back and say, I don't care what the Copyright Office says, they are misreading the Copyright Act. The Copyright Act says if you register as a compilation, you lose individual registration. You only protect the entire compilation. So that someone would have to steal every image in every fashion, in that exact order, that's what you're registering, not the individual images themselves. And the photographers relied on this letter from Nancy Wolf, who's the head of the Trade Association, from the Copyright Office. And Judge Preska said, I don't care what the letter says.
Wow.
I feel bad, very badly, that the Copyright Office misled you, but the Copyright Office does not bind a federal judge in interpreting federal law.
Well, that's why they call it a letter of opinion.
That's right. Exactly right. And so they panicked because what the judge said was it does not provide individual registrations. So what happened? We published it. It blogged all over the world. And the digital warehouse companies got together and wrote the court and convinced the photographer's lawyer to file a motion for reconsideration to Judge Preska, saying, Judge, you made a mistake.
Ooh.
And maybe you don't know the ramifications of your mistake. But
Whoa.
we're going to tell you. And they got very high-priced legal talent to write what's called amicus curiae briefs. That's friends of the court briefs, supporting the overturning of the decision, saying, Judge, you made a mistake. This would crush copyright law. We got a letter from the Copyright Office. We don't know who these photographers are. How could you do this to us? Et cetera, right? Well, just last week, Judge Preska denied her motion for reconsideration. And she said, no, I got it right the first time. And I got to tell you, Matt, I was very nervous. We were involved in a litigation with a digital warehouse, and the damages they were seeking were in the six figures against our client.
Whoa.
And in front of the magistrate judge, we made a motion similar to the motion that was made in Munch, and they opposed it, and they said, as we speak, Judge Preska is reconsidering this motion, and 5 or 6 amicus curiae briefs have been filed, and we really think that we all ought to kind of hold off on it. So everybody was kind of waiting
to see what Judge Preska was going to do.
Right. Now, thankfully, during the course of that, we were able to reach, a mutually satisfactory, amicable resolution for everybody. So we never had to. But from other cases and in other conversations on other cases, I can tell you that the digital image companies all were sure that Preska was going to reverse herself. So now the big thing, and I guess we have to wait for our next update, is will they appeal that to the Second Circuit? Because if they take that up and they lose, then we can shut our website down. We will have resolved this issue, at least in New York.
That may be good news. We might have to shut down the website. Of course, some people might not be too happy about that.
The goal, I'm being facetious, of course. Because the goal of the website is to try to restore some sanity to this issue. Okay, and
yes.
It's very clear to me, and it's common sense to me, that at the very least you cheat the government out of its fees when you take individual work of arts and register them as a compilation and then try to get protection for the individual works of art. Why would you ever? Matt, let's say you wrote 6 books. Let's say you wrote, well, you did, right?
Yes.
Let's say you wrote 6 books, and you want to get copyright protection for those 6 books. If you knew you could get the same copyright protection by taping them all together in a bundle.
Of course you would do that.
Right. Why would you pay 6 fees?
Yeah. And those fees continue to go up. It's
right. So now multiply that by 50,000 digital images.
Oh, my goodness.
Now you see what we're talking about?
Yes.
So now multiply that by 1 million images. Getty's catalog. Now where are you?
They're staggering numbers.
Staggering. And to tell Getty that you would not get protection for those images until you register them individually is overtime. It's done. They can't register them individually. They would never register them individually.
Yeah, it would put them under. Right.
So now what are the digital image companies doing? Lobbying to try to get changes in the copyright law to allow them to do this type of registration, because Congress can trump any judicial decision, even a Supreme Court decision. So, as long as they act constitutionally. So, there's a lot happening out there, and I really apologize because it's a kind of a real esoteric little legal explanation, but it goes so far beyond that little picture of, some kid throwing a baseball.
Yes.
Because it goes to all other types of works of art that could be registered as compilations or automated, updated databases. We don't know what technology is going to be out there in the future or what kind of media is going to be stored in whatever kind of fashion. And what you do is you look back at other cases with the old media and try to make comparisons. So it could have ramifications far, far into the future. So we're really watching whether these companies will appeal Judge Preska's decision on Munch. And I got to tell you something. If they don't, it still makes a very big statement. It shows that they don't feel they're going to win.
Yeah.
Because if they were sure, or more than 75% certain that they would win, they'd appeal it. They do not want that Second Circuit coming down and saying, we agree with Judge Preska.
I've got an interesting question for you. Do you think all of these different stock photo companies, do you think they collaborate?
Well, the lawyers definitely do.
Okay, the lawyers definitely do.
Of course, because you know what? While they're adversaries, they're in the same line of business.
Well, that's what I was going to say. I don't know if they were necessarily adversaries. I mean, they just represent...
I don't mean adversaries. I mean the competitors.
Yeah, the competitors, right. Not really adversaries.
I don't mean adversaries, excuse me.
Right.
I mean, they're competitors. They're business competitors.
Yeah, but they are in the same line of work, and legislation impacts one, impacts all the others.
Right. Your answer, it can be very easily seen by the way each and every other industry in this country has banded together to get legislation passed in its favor. The TARP for the auto industry and the banking industry. The railroads at the turn of the century.
Right.
The steel industry. This is no different. They have the money. They put their money together. They hire the best, and biggest law firms in the country and the best and biggest lobbyists in the country to try to make laws in their favor. That's American business, and that's not a surprise. That's the way it works. And if you think it works any other way, you're deceiving yourself, because lobbying is how legislation gets passed and created.
Now, just to be clear,
influence.
Okay, Getty is primarily it's an American company. Now, Masterfile is a Canadian company, right?
No, Getty is actually a British company now.
Oh, it started as a British company.
Getty UK.
Okay.
But they transferred all their rights to Getty US.
I got you.
Interesting. Getty US is a New York corporation, but its main office is in Seattle. So I don't know what legal benefits they obtained by setting themselves up in that particular fashion, but they are a New York corporation whose main office is in Seattle, Washington.
Now, what about Masterfile?
Masterfile is based out of Toronto, Canada.
All right, it is a Canadian company.
Right, but a Canadian company can register a work of art in the U.S.
Oh, yes, I knew that, but I just wanted to kind of, just put a perspective of where they're coming from.
Corbis is part of Bill Gates' companies.
Interesting.
It's a Microsoft-based,
Now, why haven't we heard more from Corbis, surprisingly? I mean, with all the discussions we have, it's, I'm really surprised after all these years we haven't seen somebody complain about Corbis, or at least I haven't seen it. Maybe you have.
Yeah, no, we have a handful. We have about somewhere between half and a dozen Corbis cases.
Really?
Yeah.
Okay, but why so relatively quiet? Is there something different about Corbis, or just a lower volume, or what?
I think it's lower volume.
Okay.
I also think that they maybe didn't realize, as well as Getty did, the sheer revenue stream that this would create. Even over the years, even Masterfile has kicked it up.
But surely, they must have learned about our website by now, or some of the issues.
Oh, they definitely have. Oh, believe me, they have.
How do you know this?
Absolutely. Through a number of sources, litigation.
Oh, okay.
We've been in litigation with Corbis.
Okay.
But and we have, like I said, we have about six. I think we're at about 6 or 7 open Corbis cases. Maybe not that many, because we resolved them. They're very similar to Masterfile, because Corbis does register their images, and if you respond to them early, not let it don't ignore it. That's the main thing. Don't ignore any of these things.
Yeah.
Okay, get some advice, figure out what your legal position is, where you stand, and make a reasonable settlement offer, and just move on with your life.
Yeah.
You're going to save yourself time. You're going to save yourself grief, and it's not worth fighting over a picture of a cactus. It's not worth it.
I don't think they're fighting over the picture of a cactus. What people are fighting for is they don't want to be extorted out of X amount of dollars, which they feel is too much.
Well, no, that's my point. My point is, I believe most of these companies who register, if you come at them early, before they get involved with lawyers and all this other stuff, and make a fair offer, you will 9 times out of 10 you're going to get a resolution.
That's probably true. I would have to agree with that.
You are going to get something close. Okay, maybe we can do a little better for you. We can make sure the language of the release is correct, all that kind of stuff for sure.
Yeah.
But my point is, particularly if you get us involved early, you're going to get a number that you'll say, you know what, it's not worth fighting over this number. This is a fair number for everybody. It's more than I would have liked to have paid. It's less than they probably expected to receive, but it's at least something that I can live with and feel comfortable paying, that I did not get ripped off. And so that's all I mean.
Now, I'm going to go out on a little bit of a limb here, okay? So I don't even know for the listeners, I don't even know how Oscar is going to respond to this.
I'm not surprised.
This is under the presumption that people want a resolution. Sometimes a resolution is it just kind of stays in limbo. I mean, what's your feelings on that? I mean, like if there's somebody that has 2 images out there, Okay, and they make an offer. Let's say Getty makes an offer to say, well, okay, we'll do 200 apiece or 300 apiece, which we're starting to what we consider reasonable. You know, as a client, who's to say that you have to, even if it is reasonable? You may say, you know what, this just isn't worth it all. Period. I mean, if they want to come after me, let them come after me.
That's true. You can default. First of all, even if they sue you, you don't have an obligation to defend yourself.
But that presumes that they're going to even file anything on a couple of images.
Yeah, I'll get to if they sue. Otherwise, then you have to wait out the statute of limitations.
What is the statute of limitations?
It would, in my opinion, it would be 3 years from the date you took the image down.
Now, how is that defined?
Or the date you received the letter and took the image down, because here's what happens. Look, there could be lots of legal arguments made that the statute of limitations runs from the time the alleged infringement occurred, right? And if you could show that your website was up in 1990, that the time has passed. But the problem is that image was up yesterday.
Yes.
So you infringed yesterday.
Yes.
So as long as that image remains on that website, you are infringing. Provided it's that you are infringing, then you're legally not entitled to use that image today. So until you take that image down, you continue to infringe.
Well, who establishes when you take it down? I mean, what would be the conservative approach for 3 years?
That's a matter of proof.
Yes.
The conservative approach is to write the other side saying, "Thank you very much. I took the image down on October 1st, 2010." And here's a screenshot of my website with the image no longer on.
So basically,
I refuse to pay you any damages. So good luck to you.
All right.
Okay?
So
now you got to wait till October 1st, 2014, and you're in the clear.
Okay.
2013. Sorry.
All right. Well, that's assuming today. A lot of the pre-existing cases probably rolled in 08, 09.
We started July 08.
Okay.
And I hesitate putting this in a conversation that's public. Getty may or may not be listening to, but certainly some of our earlier customers and clients have infringements that are now beyond the statute of limitations.
And you are hesitating to put that out there because?
Because I'm not like those photographers in the Munch case. I don't want to irritate a sleeping lion. If Getty is perfectly happy leaving this as kind of a standstill for now,
just leave it alone.
Leave it alone.
Yes, I tend to agree with that.
All you want is not to be bothered.
Yes.
And by the way, Getty gains because you stopped infringing.
That is true. And you know what? Word has gotten out. You can be sure most people are not going to be doing it. Consider me one of those people, even by mistake.
This is a busy issue now. I think in 10 years it won't be. People will have learned. People will realize it'll all be straightened out where everybody lies. Digital image companies will have either gotten their law changed, or the Supreme Court will have decided the issue, and people will stop, believing that just because an image, a website says these images are available for free, that it actually is. Yeah,
that's very, very dangerous. I've gotten so paranoid, I've just taken my own images. I've gone to downtown and taken some pictures of buildings, and, I've done all my newer stuff is basically my own photos.
Right. If your business, especially if your business is web-based, spend some cash and do one of two things. Either hire a photographer who will sign over the rights to the images, because if the photographer takes the picture, he owns the image, and let him give you the images and release the images to you, so that you own the images, or spend your money on a good digital camera and take the picture yourself.
Well, put my vote down for a nice digital camera. That thing pays and pays and pays for me anyway.
Remember, these are thumbnail images.
Yeah.
You're not blowing these up and framing them and hanging them in the National Art Gallery in Washington.
Exactly.
You're decorating a darn website that people are just going to look and they'll say, yeah, that's a cactus. And they move on. That's it.
Yeah.
That's what people really ought to do.
Okay.
They really just should take their own pictures.
All right.
So I think it's going to straighten out. I think that eventually we'll have a settled area of law. We absolutely do not have a settled area of law right now.
So where do you want to leave our listeners as of this update 1 year later?
Well,
until our next update, whenever that might be.
The good news is that right now, as of right now, most of our legal positions have been vindicated by the only court decisions there are in this area.
That's very good news.
We have not lost one. Okay? So everything that's been happening has been happening in our favor on a recent. So the trend is agreeing with our position. So that's the good news. And if they don't appeal it, that's also kind of the good a hint that we may be okay. So now we should watch to see whether this last decision in Munch gets appealed and what the result of that is. And we'll know shortly.
Maybe I hope I didn't misunderstand you. You also hinted or seemed to hint that Getty is considering negotiating, or trying to settle
right.
existing cases. Did I misunderstand or misinterpret? Or is that just too uncertain right now?
It's uncertain because we frankly have been doing that with them since July, on certain cases. Since early on, we've been trying to get them to settle. But they've chosen not to come down into the numbers that we agree on. They choose to disagree, with our legal positions on compilation registration and on the value of actual damages. Those are our two biggest issues with Getty. We concede the infringement. We say, forget it. Let's admit they infringed. Let's get beyond that. What's it worth? That's our point of contention with Getty. So we've had a lot of conversations back and forth with both their outside counsel and their general counsel, and even conversations in the middle of this year where we said let's get a global resolution, and we'll see. We are definitely Matthew open to trying and resolve all of these cases so that people have finality. We want finality.
Yeah. Well, in order to
wait 3 years.
Yeah, in order to get more support, one of the things I do want to acknowledge with our audience is that our website has climbed through the Google search engines over time. And most of the time, if you type in like Getty Images demand letter or extortion, Getty Images extortion, Getty Images, some permutation of that, our website will be on page 1. But one of my goals has been trying to get it to page 1 by simply typing Getty Images. And one of the things I want to update our audience is, and Oscar, you already know this, is that we've been quoted in Wikipedia. And we are not responsible. We have not, it's not like Oscar and I or anybody that we're associated with that we know of, we certainly didn't ask them to list us on that website. It has found its way into the Wikipedia. So our website and our mission is climbing.
I'm sorry to cut you off, Matt. You're right about that. Explain which Wikipedia page that we're quoted.
Well, it's a little bit further down when they're talking about copyright enforcement and so forth.
It's on the Getty Images page.
Yes.
That's my point. You type in Getty Images and you go to their wiki page.
Yes.
We're quoted on their wiki page.
Yes. But it's my hope that our listeners, if you really are supportive, we're not necessarily asking for money or anything like that, although that's welcome, donations are welcome. But one of the things you can help us do, if you really support our mission, is to put links to the ELI website, extortionletterinfo.com. The more links that we have to our website, the more prominent our website will become in this fight. So if you are a website owner or you're a discussion owner or a blogger, just link to our site and you will be able to help us on this in supporting our mission here. So that's one thing I just want to put out to everybody. Did you have any comments on that?
No, I think it's a great idea, and I think that it's a good way to support us without having to hit the PayPal button.
Yes. There's so many ways to support the mission. There really is, and we've been very grateful to all the various ways it's come out.
Even when you post on the forum, you're helping.
Well, exactly.
Content fresh, right.
Well, the thing about it is, one thing I do want to point out to the less technical oriented, that with every post, because our discussion forum has become literally a database, and so the discussion forum itself gets picked up by Google, a lot of the content. So when you contribute, even with a post, just like Oscar said, that also helps the cause. So we welcome anything that you want to contribute, whether it's a link to us, you want to post your story, you want to make a PayPal donation, you want to hire Oscar. It all helps in the cause, and it will give us a little bit more negotiating strength and power in the fight against Getty and the other stock image companies. So. Anyway, well, Oscar, I really appreciate your time in this long update, but I will probably break this up into two sections just so that people can kind of be able to listen to this without falling asleep.
Right.
We are going on about an hour and 10 minutes over, so it's one of our longer updates.
That's incredible, yeah.
So thank you for everybody. We're sorry that you had to wait so long for an update, but we hope you enjoy it. And stay with us, and we will provide another update. Thank you for listening.
Thank you, Matt. Thank you, everybody. We'll see you on the website.